On record at 10:40 a.m.
Mr. Razi, are you ready to proceed with your final argument?
Yes, ma'am.
All right. Let's bring in the jury.
All rise.
Jury in at 10:43 a.m.
Thank you. You may be seated.
Thank you, gentlemen. Mr. Razi, you may proceed.
May it please the court, ladies and gentlemen of the jury, we've been here for almost a month now, and, by my count, 17 days of testimony, evidence, over close to 60 witnesses, I think by my count, 200 to 300 pieces of evidence, exhibits, videos, and you've had a chance to consume all of those things. And today is an opportunity for the lawyers, as the judge said, to try and summarize our theories of the case. The defense trusts that what you heard over the last several weeks in terms of the words that came out of the witnesses' mouths, the form or the way they said those things, and their consistency in their testimony is really more important than what you're going to hear today. But it is nice to have an opportunity to try and summarize these things. And I would suggest to you that there's been 4 main themes that we've heard over the course of the last 17 days of testimony. The first one is a broken timeline. The second one is bungled ballistics. The third one is false confessions. And the fourth one is digital forensics, raw data that speaks the truth. Now, one of the other themes that has reared its head over the last 3 weeks is one that you really can't plan for, on the defense side, at least before you walk into these courtrooms, because you really don't know what you're going to get from the opposing party, in this case the state of Indiana. But what we've gotten, undisputed over 17 days, is a theme about what they don't want you to hear. That may be the most important theme in this entire case is what they didn't tell you. It's what we had to tell you time and time and time again, witness after witness, exhibit after exhibit. We had to do their job. And let's just think about a few of those things as we get off and running. First one that comes to mind is their refusal to have that height analysis done on that 43-second video. We heard early in this case they found an expert. They could have spent some money, and they chose not to, because they were concerned about the variation in the height, maybe being anywhere from 2 to 4 inches. I don't recall exactly what the testimony was. Again, I trust the 12 or 15 of you will look at your notes and remember that. They could have had some ranges. They could have maybe ruled out some individuals. But they chose not to do that, and they also chose not to tell you that. The second thing that comes to mind, hours and hours of video interviews lost during a critical time period shortly after these crimes in 2017. We brought that to your attention through the testimony of Officer Mullen. The third thing we did, this Ford Focus, this 2016 Ford Focus, somebody asked his question, an astute juror, they ran down and did a BMV search in the middle of the trial. Not 6 months ago, not a year ago, not 2 years ago, 3 years ago, 4 years ago, or 5 years ago, while in trial. And then, they offer you up part of the story again. In order to tell the whole story, we had to offer up the rest of the exhibit, what they don't want you to know. Brad Heath's story may not be the biggest piece of evidence in this case, but I think it's good that you, the jurors, would know that a man who drives in that area of the Hoosier Harvest Store on a routine basis noticed something unusual that day. A car that had been parked just next to the CPS building from the morning until late in the afternoon, so unusual that he noted it. We told you that. Betsy Blair's story. The state put her on the witness chair. They asked her only the questions they wanted to ask to elicit only the responses they wanted to elicit, but they didn't tell you the rest of the story. We did that through cross-examination. A youthful man, I think she said boyish-looking, brown, poofy hair, not short. They also didn't tell you about the vehicle she saw at the Hoosier Harvest Store when she left that was entirely inconsistent with a 2016 Ford Focus. And then we've got Sarah Carbaugh. I've got to take a breath before I talk about her. She, too, did not tell the whole story until cross-examination. And what you found out is entirely inconsistent with counsel's references earlier today that she saw a muddy, blood man on 300 North on February 13th. In fact, what we know is, at first, she saw a muddy man, I think 11 times in that first statement, which was shortly after the deaths of those 2 girls. And then, she was interviewed again several weeks or maybe even a month or 2 later. Excuse me for not having all the dates memorized. And then she reported in that interview she saw a bloody man, a man who had a tan jacket, until they showed her the photo of Bridge Guy, and then she changed her story. Oh, maybe it was blue. They conflate these two words, muddy and bloody, and they're off and running. Now, there's an instruction that you're going to get, and I actually think the judge may have read it, your liar, that basically says that you are the judge of the credibility of the witnesses, and I'm just going to plant this in your brains for the rest of the morning. You may discount the testimony of a witness altogether. And in our business, we actually have a phrase for this. It's not one that gets used often, but it's called the concept of incredible dubiosity. Those are kind of big words, but basically what it means to lawyers is that when you hear testimony or you receive evidence that's so preposterous and so hard to believe that you should just discount it entirely. Sarah Carbaugh and her testimony we put in the incredible dubiosity box. It means nothing, but for purposes of our discussion today and now, it's what they didn't tell you about it. David McCain didn't even bother to bring David McCain in on their case in chief. We called him. David said he was on the trail sometime roughly between 2 and 3, depending on whose version or what part of the testimony you want to believe, but a very believable man. He's out taking photos that day on the trail between 2 and 3 o'clock. He said he spent no less than a half an hour on that bridge. They didn't tell you about him because it doesn't fit their narrative. Shelby Hicks, Cheyenne Holguin, 2 more witnesses that were out on the trail that day. Shelby Hicks, by way of her testimony, sometime probably between 2:30 and 3:30, maybe even a little later. Cheyenne Holguin, by way of her testimony, probably got there, I think she said around 2:50. Again, you can check your notes, and left sometime around 4 o'clock. I think there was a time-stamped photograph of 3:49 of she and Ms. Duncan on the north side of the bridge on their way back. The state didn't offer either one of those witnesses up. Rick's version of the route that he said he traveled to the trail that day. Officer Mullen got up here earlier, Investigator Mullen, excuse me, and tried to put Rick on what? On the route that fit best for them. But in fact, we learned on cross-examination that that route is not consistent with Rick's story, that Rick actually told them he didn't know actually which way he went. They didn't tell you that. The 2 statements, the 2 interrogations, 1, the first interrogation on October 13th, and these conned on October 26th. It wasn't until Mr. Baldwin tried to introduce those statements that you saw them. And I suggest to you that when you go back and deliberate, if there's 1 piece or 2 pieces of evidence in this case that you might use to exercise your common sense and your judgment, it might be those 2 pieces. Sit down, watch those 2 statements, digest what's being said, how it's being said, the tone of what's being said, and ask yourselves, how did Rick Allen handle the situation? One of the most stressful situations a human could ever be in front of, being interrogated for the murder of 2 girls. But you weren't going to see that until we put it in. Brad Weber's lab results from his gun. Item 101. A Sig Sauer P239.40 caliber, collected from his home, could not be excluded as the gun that cycled that round. You got the exhibit, you can see it for yourself. We introduced that into evidence. The photo from Brad Weber's garage, which introduced just a few days ago, taken shortly after the murders, where on the floor you see some sticks. Seems pretty elementary in most cases, but clearly in this case, the significance of sticks in an odd place is noteworthy. A man who lives just across the creek from the crime scene. We offered that evidence, not them. Brad Weber's statement to the police. Today again you heard that he said he drove home that day, but what you hadn't heard until the testimony from Officer Goatee and, ultimately, Brad Weber himself, that he actually interviewed with Agent Pohl and Goatee back in 2017, shortly after this, and told them that he, in fact, did not go home that day, that he ran his ATM route. You heard that from us. The April 3rd phone calls. Today again the state tees up 1 phone call in a series of 3. The middle call, April 3rd at 5:14 a.m. We're going to get back to that in a few minutes. They tee up that phone call. What you do know from Harshman's testimony is there was one before that. You might find it suspicious that you didn't fear those phone calls. Why not offer up some context to you? Why not tell you the whole story? The FBI parting ways in the middle of this investigation, not offered up by the state. But when Superintendent Carter got up here a week or so ago and recounts there were issues separating the sticks that were not recovered, the blood at the crime scene initially, and I think Officer Doolin actually testified that he went back out several days later, he had to ask them to come back out and collect those items. We offer Ed that information up, the state did not. Those videos from Westville. 13 months this man sat in that isolated cell in that prison without a choice. 13 months. And all they want to talk about is what he said after he sat there for 6 or 7 months with absolutely no human interaction of any material or any substance, having been shackled every time he stepped out of that cell to go to a visit with his therapist, to take a shower, to see a doctor. All they want you to do is hear some words on a transcript or words on a recording. You must ask yourself why they wouldn't want you to see the truth. We all did that. You need context. You need the truth. And then Ms. Oberg. These infamous photos. This magic bullet, as the defense called it, was collected and clearly was the catalyst for Rick's arrest. You saw those statements. Officer Holman, their entire statement on October 26th was intensely focused on the results from that examination. They're trying to use that to leverage Mr. Allen to admit his guilt. The importance of that unspent casing really is a big part of the state's case, if not the majority of their case, because without that, Mr. Allen's not in jail. But what happened when they brought their lab analyst in? Ms. Oberg sat in here and she talked a lot. She talked a lot. And at the end of the day, basically what we got from them was, hey, she drew a conclusion. You should just believe her because she's worked at the lab for 17 years. And oh, by the way, why don't you just ignore the work product that she generated? And in fact, not only did they not offer these photographs up, they objected when we tried to. Use your common sense. And then finally, this digital phone data. Just in the last couple of days, we heard a lot of information about Celebrite dumps and other types of extractions, but what the state didn't tell you was that, at 5:45 p.m. on February 13th, there was an audio output start node on the state's own timeline that demonstrated that someone plugged that phone into an accessory. And in fact, if you look at that Cecil report, I think it is, or the Celebrite report that you have in evidence, you'll see it actually notes on there that it was headphones, inaudible. They didn't tell you about that. 1032, audio output in, same situation. They didn't tell you about that, either. And then finally, the 4:33 a.m. In fairness, maybe there was some discussion about that, but the explanation for that not offered up by the state. You should question the credibility of this investigation because of the things they're not telling you. There's also the chapter of desperation that unfolded over the last 3 weeks. First example is the magic bullet. They got that round. They interrogated Mr. Allen and immediately arrested him right after that interrogation on the 26th, and this thing moved forward. There was also that van. That one unique fact that they had mined out of months and months of therapy notes, hundreds of hours of video, hundreds of minutes of phone calls, maybe thousands. That one unique fact. And what do we find? That just recently they were running searches, talking to Brad Weber, trying to figure out a way to retrofit that fact into the narrative. When Mr. Weber testified, you may have remembered he was contacted by Officer or Investigator Mullen, who basically said it was a cold call to him. They wanted to bring him in to talk, but it was interesting that Mr. Weber himself indicated that he generated some text messages to prove his case before he got to the police department. Didn't see those text messages, not part of the evidence. In the middle of that desperation to try to fit that van into this puzzle, you didn't hear about that 2017 interview with Goatee and Agent Pohl, where he said he was somewhere else that day. And in fact, Mr. Weber actually testified that he normally drives his Subaru to work and he does not often go home after work. Those are all facts elicited by the defense. The vehicle search, again, more desperation. The vehicle search of the 2016 Ford Focus, which happened while this trial was unfolding. 7 years to figure that out. Happened just a week or two ago. DNA, we saw that. They tested some DNA a week or two before the trial started. Hair strands in Abby's hand at the crime scene. Items that were collected 7 years ago. Still trying to figure it out. Desperate. The admission of internet searches. There were some searches offered up by the state. Mr. McClelland mentioned them earlier. October of 2022, searches, he said, counsel says by Mr. Allen. There is no proof, in fact, that Mr. Allen did any of those searches. The state put in an affidavit that said it came from an email account registered to Mr. Allen. They're molding those facts into a favorable scenario, but that is just not consistent with the evidence that you have. But be that as it may, someone in Delphi is searching on the internet about Delphi murders? If that's the case, we're going to convict half of the citizens in Carroll County. Searches for the killing of a sacred deer, a movie? If that's the case, We're going to convict half the people in Carroll County. They're desperate. And then the other day, during one of the breaks, the state having realized that the 545 and the 1032 transactions on that phone existed, ran Officer Cecil downstairs, did a quick Google search, came up here, and tried to offer you up some fast food. A Google search, the same kind of search that he said he doesn't normally rely upon when he conducts investigations. Desperate, absolute desperation. And then maybe the one that sticks out the most, Dr. Kaur. It's really hard to forget Dr. Kaur's testimony in this case because of this one absurdity. He testified, when I deposed him earlier this year, I think it was in March, he acknowledged that at that scene there may have been more than one murder weapon, straight edges and serrated edges. He said nothing about anything in particular. And then we find that between the time I took his deposition and the time he testified, he walked into his garage and, all of a sudden, tada, it might be a box cutter. Of all the things on the planet that just popped into his mind. But what did you find out? 3 meetings with the prosecutor since I deposed him in March. This man has testified over 200 times. I think he said 7,000 autopsies. He's been in courtrooms all over the place. I think he even said Montana recently, or he testified in a case in Montana. No supplemental report? Nothing. No reference to. Hey, I might have changed my mind about a material fact. This is desperation at its finest. Timeline. Let's talk broken timelines. Now, there's really 3 times here that the state has offered up that matter. The 213 video is one of their bookends, if you will. The 355, the 355, 357 time, which is consistent with what they say when Sarah Carbaugh saw this image of whatever she saw on 300 North. And let me suggest this. It would not be entirely unreasonable to go back in that room and think to yourself, I don't know if she saw anything. It's not out of the realm of possibility. 213, 357, those are kind of the bookends. And then, in the middle of that, you have this 232 time, which is when the state suggests that this phone was silent and no longer functioning. By their theory, that phone was where it was recovered on the 14th around noon under Abby's body, laying on the ground. Now, their timeline is dependent upon 2 people, not to belabor the point. One of those being Betsy Blair, who saw a youthful man who looked boyish, 20s or 30s, brown, poofy hair. He didn't seem short. None of those things are consistent with 5 feet 5 inches Rick Allen. Why? It may be because she saw somebody else. Sarah Carbaugh. Not going to waste any more time on her. Her description was worthless at best. At worst, created by offering her up a photo of Bridge Guy and then asking her what she saw. You know, in our business, from time to time, we didn't have it in this case, but we will see photo line ups, where it's kind of like in the movies and somebody will. The police will be looking for the suspect. Maybe there's an eyewitness. They'll put, typically 6 or 8 individuals on a line up and they'll ask, the witness to look at that and identify somebody. And the reason why is because if you put 1 face on there or 2 then you ask, you're just more likely to get the right answer, the answer you want. It's called suggestivity. In this case, that's what happened with Sarah Carbaugh, at the very least. Why is David McCain, Shelby Hicks, or why are David McCain, Shelby Hicks, Cheyenne Holguin all important to this timeline? Mr. McCain arrived between 2 and 3. He said he was out on the trail an hour or more, if I recall correctly, at least 30 minutes on that bridge taking photos. And we know from the evidence that he was there before Shelby Hicks arrived. So you've got kind of 3 stages of individuals arriving on that bridge on that day between. It's a bigger time period, between the 2 and 4 o'clock hour, if you wanted to take it bigger. Shelby Hicks. David McCain, Shelby Hicks, Daniel Pearson, Cheyenne Holguin, and Shelby Duncan. And what we know is McCain was there first. He stood on that bridge on a day where I think Pat Brown and Jay John Sick identified as having been a very nice day. One of them mentioned that the sound, they could hear people on the bridge when down near where the girls were. This was on the 14th, but it gives you some idea of how well sound travels in that area. As the crow flies, not all that far from the top of that bridge to where those girls were at rest. McCain stood on that bridge, heard nothing. He saw nothing. Shelby Hicks said she thought she arrived around 2:30. She remembered, at some point, taking a phone call from her dad. My recollection is that phone call came sometime after 3 o'clock, shortly after 3 o'clock. She said she was almost there when that phone call came in. down the Mears connector to the right. The phone call came in. She then went back towards the high bridge with Mr. Pearson, past Mr. McCain. So you know in time and sequence, she and Mr. Pearson were second. They sat on that bridge. They saw nothing. They heard nothing. Cheyenne Holwyn shows up with Shelby Duncan around 3 o'clock, maybe 2:50, goes straight to the bridge. They walk all the way across the bridge to the south side. They got timestamps on their phone. They used the restroom on the south side of the bridge, walked back across the bridge to where Hicks and Pearson formerly were. 3:49, I think, was the timestamp on that picture when they were sitting on 10F the platforms, I think smoking a cigarette. They heard nothing. They saw nothing. Dr. Kaur said that, from a medical standpoint, it's possible that each of those girls, and I'm estimating, so look at your notes, could have lived anywhere from 5 to 20 minutes with those injuries. Vocal cords not severed, able to talk, able to scream, make noise. Despite all that, no one saw anything. No one heard anything, not a peep. The possibility of multiple actors in this case. The state has completely ignored this possibly. They don't even want to talk about it. They don't want to talk about it at all. It doesn't fit their narrative. Lots of cars and people on the trail that day heard testimony about that. The distinct possibility that somebody could have accessed that bridge from the south side, the Weber side. Teresa Liebert came in here and said she noted something unusual that day near her dead-end road. A strange man that just didn't. That was not familiar to her. She couldn't explain. It is plausible that there could have been activity on the south side of that bridge. Sheriff Leesenby's statement that law enforcement had communicated with each other that, at one time, they believed there were more people involved. That's from the sheriff in 217. Dr. Kaur's timeline, or Dr. Kaur's testimony regarding potential for multiple weapons. All those things lend to the possibility of multiple actors. But what's the reality of this? Again, the common sense side of this. On February 13th, if you accept their theory as entirely accurate, you would know that those girls were ushered down that hill, through the woods, across a creek, undressed, wounds inflicted on one of those girls while the perpetrator or perpetrators, in their case one person, they believe it's him, was controlling the other girl, wounds inflicted on the second girl, Abby then redressed, sticks retrieved and placed in an unusual formation on the bodies, and then the perpetrator flees. A very labor-intensive crime scene. 213 to 232 by their standards. That suggests a possibility of multiple actors, even if you believe their theory. They say all this was done by a 5 feet 5 inches man, done without a detectable sound, without a single trace of DNA evidence at that crime scene. The prosecutor asked you in voir dire up in Fort Wayne to exercise your common sense. Now, as that time and common sense will dictate that it's just implausible that that could have happened in that short of a period of time. What do we know about Mr. Allen's actions in February of 2017? Within a day or two after these girls were found, Mr. Allen called himself out to local law enforcement, picks up the phone, he calls the police, says, "Hey, I was out on the trail that day. I'd be happy to help. Where would you like to meet me?" They end up at the Save-A-Lot, talks to Officer Doolin, hands him his cell phone. Officer Doolin records that information. And Officer Doolin said during that interview, the experienced law enforcement officer that he was, still is, said there as nothing unusual about that meeting with Mr. Allen. Even in 2022, he was cooperative with the police. Took him into the station, Sheriff Liggett, and I think Investigator Mullen. I might be mistaken about that, interrogated him. He stood there and he told them he didn't do it, he couldn't, inaudible, and he cooperated. Then, on October 26, 2022, knowing at this point that he's a suspect, what does he do? He goes back into the station, cooperates again. And in the face of lies, call it the Reed technique, call it whatever you want, what we all know is it's a lie. In the face of those lies about that bullet coming from that gun, and about his voice being determined to be the one on the video, and about witnesses eyeing him at the trail, he asserts his innocence. And the state wants you to believe that because the tone of his voice changed by one note, that somehow that's evidence of his guilt. Insulting. I suggest to you that if somebody was bearing down on you for the murder of 2 girls, your response might be the same. Then his wife was leveraged to try to get him to come clean. He stood his ground. He said, "I didn't do this. I don't know how this happened. I cannot explain something that I don't know. What other explanation is there?" And finally, 4 or 5 years after these girls were found, Richard Allen lived in this community, He worked right down the street at the CVS, a place where the public comes into every day. He had a chance to get out of here. He had a chance to lay low, but there was no reason for him to do that because he wasn't responsible for these crimes. That magic bullet. Let's talk about that magic bullet. Item 016, a case of bungled ballistics. Questions about that cartridge from the get-go. Collected underneath some leaves on the ground in the woods. Poorly photographed. That cartridge ends up at the lab, and Ms. Oberg examines the cartridge and, eventually, receives the firearm from Richard Allen's house. Now, this is important, and this is kind of second-layer stuff, but you did hear about some of this bias, confirmation bias, things of that nature, with these exams. It's always good in these examinations to be kind of blind about what you're doing. But in this case, because they had this cartridge way ahead of time, there was some discussion about, hey, this is the kind of firearm it might have been cycled from. We have some ideas. I think some of the testimony was it was a SIG or a Smith & Wesson. And so when Mr. Allen's Sig Sauer was Brugg HT to her, they had already kind of narrowed this down possibly to two different firearms. But what we know is that when Ms. Oberg took some stock rounds out of that cabinet, out of their vault, she placed it in this firearm. 4 to 6 times, I don't recall exactly, she cycled those rounds. And what we know is the marks on those test-cycled rounds were not sufficient to compare with the magic bullet. So what do we get? Apples to oranges. She shoved some test fires in that gun, starts firing away, Toda LLY different environment. Dr. Warren talked to you about that. Higher intensity changes the nature of that environment. But she does that, not necessarily improperly, but she does that, and she starts off on her examination, comparing apples to oranges AGI. Dr. Warren said that can still be done, but here's the problem. It requires a lot more work, a lot more intensity, a lot more corroboration, a lot more research, and you need to explain your work. You need to offer it up. It needs to be vettable. Subclass versus those individual characteristics. I'm not going to bore you with that for the rest of the afternoon, but what we know is that that is where the battle lines are drawn in this industry. You've got to be able to distinguish between individual characteristics and subclass characteristics, or it's not helpful at all. And in this case, with regard to those 3 tools, the ejector, the extractor, and the barrel hood, she documented her subclass findings only with the ejector. She documented nothing with the extractor and nothing with the barrel hood. And as it turns out, in terms of peer research, error studies, there really isn't any that even exist when you're comparing apples to oranges, cycled, unfired rounds versus fired rounds. And then came the photograph discussion. Of all the things that we've heard in this case that should upset you, and that should cause you consternation and concern about the task that's been placed on you are these photographs. They had the hairline down the middle. You can look at the 2 sides. If you're as old as I am, you may remember ant races on TV. To me, I think a reasonable person would look at these and say, this is like ant races. I don't even know. But if you believe that these are helpful to you, take a look at these, stare at them, and ask yourself, where in the hell are the sufficient agreements? Where are the ridges that match? In fact, there's way more that doesn't match than what matches on every one of these photos save one. I'll show you that photo in a minute. And again, item LL, to the extent you believe there's a match there, you're entitled to your opinion, as my colleague once said. Use your eyes and your ears. Use your eyes. See for yourself. Item NN. I don't know how you could make any sense out of item NN, but that's a photo that she took that, apparently, has no meaning to her evaluation. And then, item MM. We've got some areas here where there's some similar lighting, but a lot of areas that are different. I don't understand ING what's going on with that. She took the photo. And then, item OO, maybe the most notable photograph in this case. You may recall Ms. Oberg herself acknowledging. And if you look at this photo, I think the first thing that jumps out at you is there are some similarities there. There are some ridge lines there that are illuminated that are kind of close. But what you would also recall from the testimony is that both Ms. Oberg and Mr. Warren, Dr. Warren, have identified that this is classic subclass characteristics. Ms. Oberg said, at one point, well, there's some other marks that I'm looking at. But these matching marks, if you will, to the extent you believe they're matching, are classic subclass characteristics. This photograph is why a really good example of why this is a dangerous business. The science, if you will, I'll concede that you can call it an applied science, Although there are distinguished bodies in this country that don't agree with that, but the science, if you will, is under fire. There was a laboratory in Rhode Island that was shut down because they weren't distinguishing between subclass and individual characteristics just recently, about a month ago, in fact. This is a subjective game. MS. Oberg sat here and told you. I get to see a motion picture. I get to take the pictures that I want to take, but you should ignore those in this case, because they're not important or they're not reliable or they're not valuable, or whatever word you want to use. You should just believe me. That's what she told you. And if that's enough for you in a matter of the highest importance, then there's nothing I can do about that. The question then becomes, why didn't the defense have this bullet examined? An explanation might be that after consulting with Dr. Warren, there was no point in doing that, because the work was so poor. It's also not our burden of proof to offer up his innocence. It's their job. It's their job. It's their burden of proof. Why didn't they get that bullet re-examined after it was in dispute? 7 years they've had it. And then we've got those false confessions. Life in solitary confinement. Rick Allen's situation in this case is unprecedented. The warden himself acknowledged that in 25 years that he worked at the DOC, he was not familiar with a circumstance like this. At least in the last 3 to 5 years, I think he said 5, maybe 3 to 5 that he was working at Westville. He had never had a pre-trial detainee without a criminal history in the WCU. Absolutely unprecedented. Dr. Walla herself acknowledged the same, that Mr. Allen's circumstances were unlike any she had ever seen. And I think Dr. Martin even told us the same thing. A man who had been in the prison system in Florida for years, he remembered that. He distinguished between pretrial detainees being held in jail versus those being held in prison, whether they were in a circumstance like Mr. Allen's. Mr. Allen was a fragile egg when he landed at that doorstep. There was a little bit of back and forth about whether or not he had a serious mental illness. That was cleared up yesterday by Dr. Martin. It's a DOC designation. It's a business designation, major depressive disorder. I would suggest that that really is a serious mental illness. Dr. Walla herself admitted it, but it is a business designation. Dr. Westcott said that he had. I think she defined it as a critical mental illness, or there was some other phrase. I'm sorry, it eluded me, but that he did have a serious mental illness. He was tossed in the most secure unit in the state of Indiana, and he was treated just like Therist. That's what we heard. He was treated just like Therist. Therist of the convicted murders that were his cellmates. Therist of the convicted child molesters that were on that unit. The most heinous individuals in the state were his neighbors, and he was treated just like them. In fact, not only was he treated just like them, he was immediately placed on suicide watch. The evidence suggests that no human, no matter how strong, could endure those conditions for that long a period of time without having some kind of breakdown. Stripped of almost every necessity of a man's life and sent to a place where you have very few, given a suicide smock, basically a caveman gown. You have to eat off the floor, compete with mice droppings, ants. All the while, his neighbors calling him a child killer, a baby killer. In an 8x12 cell, cinder block walls, concrete floor, no blanket at TIMES, steel toilet that was next to his, where he laid his head at night. And if that wasn't enough, when he got out of that cell 3 to 5 times a week to go to rec, he got to go to a similar unit, similar cell. They call it outdoor rec. It's a cage with a screen on top. I recall asking Warden Gallipo at one point about Rick's opportunities to go to rec. There are rec yards all over that facility, ball diamonds, volleyball courts, basketball courts. He didn't see one, not one time. On top of that, when he got to go to therapy, shackled his arms, put a box cuff on him, his legs, belly chain, a lead, I call it a leash, argue about that all you want. And he was walked to a cage down the hall where he got to talk to his therapist. Same with the shower. The 30-day rule in the DOC, the 30-day rule. Here's the point. Solitary confinement is damaging to a man or a woman's brain. It doesn't matter if you have a business designation as a safekeeper. If you're held in solitary confinement, Dr. Gracian said the international standard was 15 days. But when you're held in solitary confinement, the evidence is firm that eventually you're going to break. You can only handle so much. Rick Allen, more than 30 days, those 30 turned to 60, 60 turned to 90, 90 to 120, and I could keep doing the math. What the dust settled, he was there for 13 months. How much can one human endure? How much? And they didn't want to show you the video. They didn't want you to see that. It's insulting. The state's response to this, Trooper Harshman, certainly a good cop, says he was right where he belonged. They could see that he may have been psychotic. Well, Dr. Walla, I wouldn't put any credence in what she said. Her testimony is he was psychotic from March, April, May, and June. They're willing to concede that he may have been psychotic, the state is, but they want you to cherry-pick somewhere in the middle. He's psychotic on May 13th, but not on the 14th. So let's take that statement and let's throw that upon the screen and hit play. He was getting stuck with needles during that whole time, all the way into mid-June, antipsychotics, which means, by extension, that you're psychotic. They wanted to say he was faking it, but they didn't want to show you his body language when he was saying these things. But as it turns out, Dr. Walla herself said even after some forethought, hindsight, that even she wasn't sure if her note regarding the feigning behavior was accurate. She said, I don't know. Dr. Martin yesterday, after watching that video, on the day when Dr. Martin claimed he was oriented to time and place, then changed his mind right there on that stand. Who wouldn't? Who could possibly watch that video and, for 1 second, believe that that man was oriented to time and place? What did we find out about the standard at the DOC when it came to the care of this man? It was to keep him alive. That was it. That was the medical standard within which these people were working to keep him alive. You should be insulted. Dr. Gracian talked on a more technical level about delirium and false beliefs and false memories. A man who's seen this time and time again over his 30 or 40 or 50 years. I've forgotten that. I think he said he started practicing in the 70s. False beliefs. False memories start out as false beliefs, is what the testimony was. They're not based on actual factual circumstances. They're based on beliefs. I suggest to you to go back and look at that April 3rd, 5:14 phone call, the only one that they want to show you. Go to page 4, and at the top, Rick starts off the phone call. I did it. You did what? No, I did it. I killed Abby and Libby. And then, by the time you get to the bottom of that page, a few lines down, you start to see these signs of these false beliefs. No, I mean, evidentially, or I evidentially did it, because maybe I did it. I think I did it. Then Rick starts to communicate how he thought maybe he called his father earlier. He couldn't remember. And then he says, page 5, line 22. I think I did. Line 24. Because I think I did. Page 6, line 1. I wish I could say I didn't. I don't know. I just wish they'd kill me and let me apologize. Those are false beliefs. Dr. Gracian said classic case. And then there's the iPhone, Libby's cell phone, Apple 6S I think is what it was. Does that thing ever have stories to tell? Yes, it does. The state has relied on that heavily and want you to believe that the information they offered up about that phone is accurate. There were 3 timestamps in that phone that I already mentioned to you, 5:45 p.m., 10:32 p.m., and 4:33 a.m. How do you interpret this information? And I suggest you think about this first. That phone has no personality. It has no feelings. It has no emotions, no opinion. It just generates raw data. It speaks for itself. One of the most common tools in law enforcement these days in solving crimes. There's one simple conclusion to be drawn by this 5:45, this 10:32 time frame, and that is that someone was using that phone. Someone plugged something in. That phone went dead after 4:33 a.m. You heard testimony that there wasn't any activity after that. That makes sense. There wouldn't be any Apple Health activity because it was dead. But we do have Apple Health data from earlier, Mr. McClellan mentioned in his opening or his closing. There's a reference on there to a 20-foot change in elevation. You've got a map of the south side of that bridge. You should revisit that map. David McCain said, and I'm approximating, that the distance between the top of that bridge and the water was about 65 feet, I think is what he said. He knew that place well. He was part of the effort to establish that bridge and that trail. Exercise some common sense. Go to the south side of that map or the bridge on that map. Look at that Weber Road, and you're going to see it's about halfway down to the river bottom. That private driveway, about half of that 60 feet, 30 feet maybe, we can approximate. I don't know when 20 goes to 30 on the Apple Health phone. I don't know if it's at 29.05 that it switches to 30. I don't know. But what I can tell you is that the location of that road relative to that 20 feet is curious at best. Not ironically, that private road leads to Brad Weber's home. Not ironically, he had sticks in his garage. And not ironically, he had a Sig Sauer P239 that couldn't be excluded as one of the firearms that cycled that round in this case. It's the state's burden of proof. It rests squarely on them, not U.S., and the state had 7 years to figure out 545 and 1032. There's no explanation because the phone is right. It's right. You need facts. The state wants you to believe there's this box cutter. We talked about that earlier. Dr. Kaur's testimony is hard to swallow. The timing, even his tone, and the way he testified. You can draw your own conclusions about that, but it seems like a retrofitting of that particular fact. By the way, it's also a box cutter. It's one of the most common tools on the planet. They searched Richard Allen's house. They wanted you to see those knives earlier, when they put them upon the screen. They wanted you to see those box cutters. But there's not one piece of trace evidence on any of that connects him with the murder of those 2 girls or that crime scene. They have no proof that he discarded anything. That's just a statement with no validity. The van comment. And again, we know there's discrepancy in Mr. Weber's statements. It's a van, too. It's van. Again, one of the most common vehicles we see on the roadway. God only knows what a BMV search might have shown as to how many vans were in Carroll County in 2017. And then Dr. Westcott had a really she had a really interesting observation when she testified the other day, and it was this. She noted that the medical notes that was her version or her summary of what Rick Allen told her during some of these therapy sessions in the cage flowed like a story. But for 4 months, this man was in a psychotic state, disorganized speech, fragmented thoughts. No man in that state would talk like that, would be able to provide details like that, but yet, those things showed upon paper. Dr. Wallace's circumstances in this case and her involvement in this case are clearly an issue that you need to tackle. The word bizarre comes to mind. The psychologist, I should say, who was infatuated with this particular case, who was assigned to him, and didn't disclose her personal interest in this case until after she was assigned to him. She visited the Monon High Bridge. She lives in North Chicago. She works in northern Indiana. It is fair to question the accuracy and the authenticity of her work. The unique fact that he lied in wait before those girls were ushered down that hill. Well, look at the video. Does that look like somebody who's lying in wait? In fact, they put forth testimony that he was standing on one of the platforms on the bridge earlier, and there was somebody staring at him, Betsy Blair, and that he walked down the trail. If you believe the statements from the state, Voorhees, and Wilbur saw him. That's not lying in wait. Then they want to retrofit this idea that, oh, in that video, now you can hear the gun cycle. Well, you can play the video again. There's a lot of crunching and munching and a lot of other things you hear. The video's outside. But to fit their theory, they're interpreting one of those sounds as being a gun being cycled, and there's just really no proof of that. None. I should have stuck that in the desperation column. And then they wanted you to believe for a few days that Richard Allen was an alcoholic because one of the statements from May suggested that he drank some beers and somehow, being an alcoholic is consistent with somebody who drinks a few beers and go out on the trail. Look at your medical records. I think there was some testimony yesterday from Dr. Martin that Richard Allen disclosed to him that he drank occasionally. No references to him being an alcoholic. Desperation. The search for the girls has been called into question. From what we know from Mr. Starrett is on February the 13th that there were search crews sent out. Some of them were service personnel, firefighters and such. Others were just lay people trying to help. And we know that search went in somewhere between 9, 10 o'clock, and 2 in the morning, both sides of the river. I should say the creek, both sides of the bridge. Mr. McClellan's argument is they weren't looking for dead girls, so they wouldn't have found them. There were no leaves on trees in February of 2013 sick. The visibility was great. I think Jake Johns or the other gentleman that was out there, Pat Brown, said that you could see a cool 100 yards even at one point. You can check your notes on that. But basically, from close to that cemetery all the way down to where those girls were found. These people had lights. They were on foot. Mr. Starrett said they were moving hastily, try ing to cover a lot of ground. There are a lot of questions about whether or not the girls were there on the evening of February 13th. The state's theory, back to this lying in wait, is that he was walking with a purpose that day, suggesting that Mr. Allen had a plan, that he must have known these girls were on that trail, walking with a purpose. But yet, There's not one single item of digital evidence, social media, or any connection whatsoever, whether it be a familial connection, a work connection, between this man and those girls, nothing. His clothing. Counsel says he's wearing the exact same clothes. They collected a Carhartt jacket. Boy, there's a revelation for you. A blue Carhartt jacket in a closet in Carroll County, Indiana. The Hope Box. He's got a Hope Box, and there's a round in there, and it's a Smith & Wesson .40 caliber. Mr. Doolin testified that Smith & Wesson rounds, very common, one of the most common manufacturers in the industry. You can go back and check your notes, but Oberg had that round. That was closet round number 1. And you can check your notes, but my recollection is that she couldn't generate any comparisons between the cyclings on that round and the cyclings on this one. Counsel said earlier that Richard Allen found the Lord, and that's why he came clean. In that 8x12 cell with no bed sheets, with nothing other than a Bible for months, what does a man find? Can you blame him for taking out that Bible? Can you blame him for trying to find a way out of that circumstance? He's not the only guy who's found God in prison, you can rest assured. And then, the voice on that video. The state says Trooper Harshman identified Rick Allen as the voice on that video. But you heard Investigator Mullen the other day on the stand. Over the course of the 5 years of this investigation, phone call after phone call after phone call, tip after tip after tip, people who were called in and saying, I know whose voice that is, it's Bob Smith, it's Jerry Smith, it's John Doe. Dozens and dozens. I think he even said maybe hundreds that they know of. And all of a sudden, somehow, Trooper Harshman, mind reader, is able to identify Richard Allen's voice as the one on that video. Exercise your common sense. Speaking of common sense, there is the 10,000-foot view of this case, and that's simply this in 5 parts. No one identified Richard Allen as the man on that bridge, not Ms. Voorhees, not Ms. Wilbur, not Ms. Blair, and sure in the hell not MS. Carbaugh. And in fact, if you believe what they said, they were actually identifying people that were not Richard Allen. Number 2, no one piece of digital data from any phone, any tower, or any form of social media connects Richard Allen to that crime scene or those girls. Number 3, not one fingerprint, shoe print, or other piece of clothing connects Richard Allen to that crime scene or those girls. Not one scrap of DNA on either of those girls or any of the surfaces around that scene connects Richard Allen to those girls or that scene, a very labor-intensive scene. Not one speck of trace material was found in Richard Allen's car or his house that connects him to those girls. If you want to believe Sarah Carbaugh, Ms. Muddy and Bloody, Ms. He slaughtered a pig. You bet your bottom dollar when he got into that car, he would have left some trace evidence. That car was collected by the police and secured, examined. Even if it's 5 years later, in the world we're living in, they'd have found something. It's unprecedented in the modern era of law enforcement investigation that they would have no forensic evidence connecting Mr. Allen to that scene. Now, as the judge said, the rules permit me to speak only once on Mr. Allen's behalf. It's been a long haul to get to this point, not nearly as long as the journey that the Williams family has had or the German families, the Patty family, not nearly as long as the journey that the Allen family has had to get to this point, and certainly not nearly as long as the journey Mr. Allen has endured as he was processed through the doldrums of the DOC. At the end of the day, the state's timeline has crumbled. The magic bullet is nothing more than a tragic bullet. It was the catalyst that landed Rick in that DOC, a terrible place. At the end of the day, they want you to ignore this. 5:45, 10:32, and how? All of a sudden, at 4:33 a.m., by their theory after that phone had laid under that young lady's body for hours and hours and hours, all of a sudden it receives service. It doesn't make any sense. That phone has no personality. It's not manufacturing facts. It's raw data. All those things make it virtually impossible that Rick Allen was responsible for these offenses. But let's just say for a second that you want to buy into the idea that they've got the smoking gun because Richard Allen confessing these crimes. If even for a second you're inclined to consider those claims, consider this. This here is called a rack. It was a tool that was used in medieval times to punish people, even up until the 13-14-1500s. Here's a picture of what it might look like back in the very early days. There's also a tool called thumbscrews. Thank you, Max. Another medieval device that was used to interrogate people. This is what it might have looked like back in the day, an illustration. But as a society, We've evolved. It happens. This, ultimately, gave way to other forms of interrogations, more subtle ones. One of those forms was throwing somebody in a cell and throwing away the key. It's called solitary confinement, a much slower and more painful form of punishment and interrogation. Whether intentional, reckless, or negligent on the part of the Department of Corrections, somebody should have spoken up, a team or 4 or 5 doctors, police officers watching these videos every day, the warden visiting the cell. When was somebody gonna say, something's wrong here, this ain't right? Where is the moral compass? You're the moral compass. You may have thought we moved away from such harsh practices. Every now and then, our system of justice, we're confronted with circumstances that remind us and redirect us in another direction, another course of action, another way to handle things. That time is now. That's the power of the state, and it might be a crude example, but it makes a point. Now's not the time to step back to the Middle Ages in terms of crime and punishment. Now's the time to step into the ring, to have a voice and acknowledge that this isn't the way we punish people. No man or woman should be treated like this, whether guilty or innocent. And rendering a verdict of guilt in this case would be endorsing this behavior, this process. You should not do that. We're asking you to set Rick Allen free, and we're asking you to find him not guilty of these crimes. Thank you.
Well, ladies and gentlemen, we are gonna go ahead and take our lunch recess. While you're outside the courtroom, keep your minds open. You may discuss the evidence so far, but please, only do that if all 15 of you are present in the jury room at the same time, and please, don't deliberate. Gentlemen.
All rise.
Jury out at 12 p.m.
Let's resume at 1 o'clock. Jody, you can go off the record.
Off record at 12:01 p.m. On record at 1:04 p.m.
All right, we are back on the record. Oh, where's Mr. Rossi?
He had to run to the restroom. He'll be right back.
And when he returns, are you prepared to proceed, Mr. McClelland?
Yes, Your Honor.
All right. Mr. Rossi, are you prepared to proceed?
Yes, ma'am.
Let's bring the jury, please.
All rise.
Jury in at 1:06 p.m.
Thank you. You may be seated.
Thank you, gentlemen. I'm just gonna give you a minute to get all your things out for note-taking purposes again. All right. Well, as I indicated to you, the state has its rebuttal argument prepared for you. Mr. McClelland.
Thank you, Your Honor.
Could you turn your table mic back on, please? Go ahead.
Thank you, Judge. Ladies and gentlemen, it's been a very long 3 or 4 weeks we've spent together. You've heard a lot of evidence and heard a lot testimony and seen a lot of evidence. And now is the time we hand the case over to you and you're in the driver's seat. Not the attorneys, not the judge. They don't decide the facts and the law. You decide what those are. The judge is gonna give you instruction on what the law says, but you decide how that applies to the facts and the testimony. You're in the driver's seat. And so I'm not up here to tell you when you should be offended about things, and when you shouldn't, or how you should feel. I'm up here to tell you to surmise the evidence that the state has presented to you. Way back in the beginning, there were opening statements that we did, many opening statements in Fort Wayne, and then opening statement to us here, and the defense went through a lot of stuff and a lot of things that they said the evidence was gonna show. But I present to you that they haven't backed up those claims. I used the phrase that this is about bridge guy, a bullet, and a brutal murder. I said that a couple times, told you that I was gonna introduce evidence of confessions that included detail that only the killer would know. And we've done that. The state has done that. The state's presented evidence to you of witnesses that were on the trail that day, and witnesses that described a man that they see walking on the trail that day and on the high bridge that day, and they give a description of that man, and they all identify that man as Bridge Guy, which is really just reaffirming what Richard Allen said himself, that he was on the trails that day from 1:30 to 3:30, and that he was wearing clothes that matched the clothes that bridge guy was wearing. So those affirmations by those witnesses just reaffirm what Richard Allen tells you, that he's there, he's on the bridge. We then have the video from Libby's cell phone. It tells you the exact time they were abducted. 2:13 p.m. Witnesses on the bridge and on the trail after that are irrelevant. The abduction has really happened. The phone stops moving at 2:32 p.m. It's underneath the body of Abby. Hard data. They want to say hard data. That's hard data from the phone. You get to the crime scene and this notion that, oh, since they didn't scream, it didn't happen. Richard Allen had a gun pointed at them, used the gun to execute power over them. We know they didn't scream, but we know Libby was crying, blood outline of a tear on her face, scared, fearful, all because of Richard Allen. We know that when he left behind his calling card, a bullet, and I don't understand, and I don't comprehend how this is a magic bullet. It goes from the crime scene to the lab with Stacy Bozanovsky and Melissa Obogue to be tested, and she testifies, in her expert opinion, that bullet was cycled through Richard Allen's gun, a gun that he never loaned to anybody, that he never let anybody borrow, ammunition that he never loaned to anybody. And she told you why she thought what she based that opinion on. The defense wants you to look at the pictures and say, "Look, these don't match." She told you, "You can't use those pictures. I'm looking at a 3D image. Those are 2D images." Her results were even verified. The defense had an expert witness. He could have tested the bullet. He didn't. Not only that, he didn't write a report, didn't give any findings, nothing. I don't understand how that's a magic bullet. Magic in the sense maybe to the defense because it links Richard Allen to the crimes. I'll go with that. And then, we go to the confessions. Throughout this case, the defense has repeatedly said words matter. Why don't Richard Allen's words matter? He said a lot of words to a lot of different people. His mom, Kathy, Dr. Walla, detailed confessions to Dr. Walla. I lied in wait. My intent was to rape the girls. I thought they were older than they were. I messed with the gun. I forced them down the hill, and I saw a van and I got scared. So I walked them across the creek, and I slit their throats. Words matter. And this is not to a stranger, Dr. Walla. He trusted Dr. Walla. You can hear that in the phone call to his mom. We played a phone call last week where he called his wife, while Dr. Walla was in the room and confessed to his wife in front of Dr. Walla. He wanted Dr. Walla in the room. He trusted her. Words matter. The confessions he gave are organized. They're logical. They talk about details, and they talk about details that only the killer would know. The evidence presented in the case shows that Richard Allen is Bridge Guy and that Richard Allen killed Abby and Libby. There are two victims in this case, Abby and Libby. Those are the two victims of Richard Allen. But they're more than victims. They're also heroes. Libby for making the video, for recording a Bridge Guy, Abby for concealing the phone for law enforcement to later find, and both of them for camouflaging the bullet that Richard Allen left behind. Those pieces of evidence helped law enforcement find Richard Allen. I'm gonna leave you with this. When Becky was on the stand, she mentioned that, at one point, Libby told her, "Someday, I'm gonna grow up and help police solve crimes." Exactly what she did, and she brought Abby along to help her. Thank you, Judge.
Ladies and gentlemen, I'll now present the balance of the instructions to you. Those are the last 7 pages at the back of your packets. And again, I'm required to read these, so you may follow along if you wish with the copies that I have provided. All right. Juror 11 in seat 13, Juror 2 in seat 14, and Juror 9 in seat 15, you are instructed that you shall accompany the jury into the jury room, and please pay careful attention to the deliberations of the jury. You are instructed that you may not participate in the deliberations unless directed and ordered to Sobith Court. The defendant has entered pleas of not guilty, and the burden rests upon the state of Indiana to prove to each of you beyond a reasonable doubt every essential element of the crimes charged. The charges which have been filed are the formal method of bringing the defendant to trial. The state has the burden of proving the defendant guilty beyond a reasonable doubt. Some of you may have served as jurors in civil cases, where you were told it is only necessary to prove that a fact is more likely true than not true. In criminal cases, the state's proof must be more powerful than that, it must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every possible doubt. If, based on your consideration of the evidence, you are firmly convinced the defendant's guilty of the crimes charged, you may find him guilty. If, on the other hand, you think there is a real possibility that he is not guilty, you should give him the benefit of the doubt and find him not guilty. The burden is upon the state to prove beyond a reasonable doubt that the defendant is guilty of the crimes charged. It is a strict and heavy burden. The evidence must overcome any reasonable doubt that concerning the defendant's guilt, but it does not mean that a defendant's guilt must be proved beyond all possible doubt. A reasonable doubt is a fair, actual, and logical doubt based upon reason and common sense. A reasonable doubt may arise either from the evidence or from the lack of evidence. Reasonable doubt exists when you are not firmly convinced of the defendant's guilt after you have weighed and considered all of the evidence. A defendant must not be convicted on suspicion or speculation. It is not enough for the state to show that the defendant is probably guilty. The state must prove each element of the crimes by evidence that firmly convinces each of you and leaves no reasonable doubt. The proof must be so convincing that you can rely and act upon it in this matter of the highest importance. The rule of law which requires proof of guilt beyond a reasonable doubt applies to each juror individually. Each of you must refuse to vote for conviction unless you are convinced beyond a reasonable doubt of the defendant's guilt. Your verdicts must be unanimous. Under the law of this state, a person charged with a crime is presumed to be innocent. This presumption of innocence continues in favor of the defendant throughout each stage of the trial, and you should fit the evidence presented to the presumption that the defendant is innocent if you can reasonably do so. If the evidence lends itself to two reasonable interpretations, you must choose the interpretation consistent with the defendant's innocence. If there is only one reasonable interpretation, you must accept that interpretation and consider the evidence with all the other evidence in the case in making your decision. The defendant has not been required to present any evidence to prove his innocence or to prove or explain anything. The fact that charges have been filed, the defendant arrested and brought to trial, is not to be considered by you as any evidence of guilt. You are the exclusive judges of the evidence, the credibility of the witnesses, and of the weight to be given the testimony of each of them. In considering the testimony of any witness, you may take into account his or her ability and opportunity to observe, the manner and conduct of the witness while testifying, any interest, bias, or prejudice the witness may have, any relationship with other witnesses or interested parties, and the reasonableness of the testimony of the witness considered in light of all of the evidence in the case. You should attempt to fit the evidence to the presumption that the defendant is innocent and the theory that every witness is telling the truth. You should not disregard the testimony of any witness without a reason, and without careful consideration. If you find conflicting testimony, you must determine which of the witnesses you will believe, and which of them you will disbelieve. In weighing the testimony to determine what or whom you will believe, you should use your own knowledge, experience, and common sense gained from day-to-day living. The number of witnesses who testify to a particular fact, or the quantity of evidence on a particular point need not control your determination of the truth. You should give the greatest weight to that evidence which convinces you most strongly of its truthfulness. During the progress of the trial, certain questions may have been asked and certain exhibits may have been offered which the court ruled were not admissible into evidence. You mustn't concern yourselves with the reasons for those rulings, since the production of evidence is strictly controlled by rules of law. You mustn't consider an exhibit or testimony which the court ordered stricken from the record. In fact, such matter is to be treated as though you never heard it. Nothing that I said during trial was intended as any suggestion of what verdicts you should find. Each of you, as jurors, must determine the facts and the verdicts. The evidence must be judged and considered from your memory of the testimony of the witnesses, and such exhibits as may have been admitted for your examination. Transcripts of witness testimony will not be available to you during your deliberations. Materials which were reviewed by witnesses or mentioned by the attorneys that were not admitted into evidence will not be provided to you during your deliberations. The unsworn statements or comments of counsel on either side of the case should not be considered as evidence in the case. It is your duty to determine the facts from the testimony and the evidence admitted by the court and given in your presence, and you should disregard any and all information you derive from any other source. Your verdicts must represent the considered judgment of each juror. In order to return verdicts of guilty or not guilty, you must all agree. During your deliberations, you should not yield your individual judgment to a fellow juror just so that you can return verdicts. However, it is your duty to impartially consider the evidence with your fellow jurors, to examine your own views in light of your discussions, and to consult and reason with your fellow jurors in a good faith effort to arrive at just verdicts. After you return your verdicts, you are under no obligation to discuss them or the reasons for them with anyone. After you've retired to your jury room, the bailiffs of this court will be in attendance, but they cannot be present in your jury room during any of your deliberations. Should you at any time during your deliberations of the cause leave the jury room, you must leave in a group and at all times be in the charge of the bailiffs. While you're absent from the jury room, you mustn't talk about the case among yourselves, with the bailiffs, or with any other person. When you've agreed upon verdicts and such verdicts have been signed and dated by your foreperson, you will inform the bailiffs you've agreed. You will remain in the jury room until the bailiffs, on court order, conduct you back into open court, where your verdicts will be reviewed and read by the court. Neither sympathy nor prejudice for or against the witnesses, or the defendant in this case, should be allowed to influence you in whatever verdicts you may find. These instructions do not contain any information concerning the penalties that could be imposed upon a conviction. I am solely responsible for assessing the penalty within a broad range of possibilities. The law has been written so that you may make your decision without being influenced by the apparent severity or leniency of the sentence. The court is submitting to you forms of possible verdicts you may return in the case. The forms will be supplied to you when you retire to the jury room for deliberations. Upon retiring to the jury room, you will select one of your members as foreperson. The foreperson will preside over your deliberations and must sign and date the verdicts to which you all agree. The foreperson must return the verdict forms back into open court.
Bailiff sworn.
All right. Verdict forms. Ladies and gentlemen, take all of your material and your papers. The bailiffs have your verdict forms, and will bring in the evidence that we can bring into you.
All rise.
Jury out at 1:23 p.m.
You may be seated. I'll show the jury out at 1:25. Are there any objections to the court's instructions as read, Mr. McClelland?
No, Your Honor.
Mr. Rossi?
No, ma'am.
Please leave numbers with Jody, so that we can find you if they have questions, or if they want to see the evidence. You need to be within 5 minutes of the courthouse. Please don't leave the vicinity of the courthouse and drive to Logansport again. I really need to have access to you immediately and have your input if they do have questions or they want to review the evidence. We will be clearing the courthouse and locking, or not the courthouse, but the courtroom and locking the doors. If the jury needs to get out of the jury room for whatever reason, 'cause it gets kind of cramped and small in there or they want to stretch their legs, we'll be using the courtroom for that purpose, so we'll be clearing the courtroom and locking the doors for that. If they want to review the evidence, I think both of you invited them to listen to things and watch things. I'll advise counsel and I'll expect you to be here, and the defendant will be brought in, as well. I would ask though that you will probably have you in the back of the courtroom, so that you can observe that process while they review whatever evidence it is that they'd like to review.
Judge, we talked at some point, about waiving counsel's presence. Is that something the court's willing to consider? I don't need to be here. I suppose I'm willing to waive it while if they want to review evidence, Just throw that out there, Judge.
We don't have any issue with that. I mean, as long as we're invited, we can have the opportunity, and I know we would be.
Of course you would be.
And
if you'd like to be here, then I would require the state to be here.
Sure, Judge, I understand.
And then, we would bring Mr. Allen in as well.
okay.
Okay. All right. Is there anything else that we need to do on the record before we clear the courtroom, Mr. McClelland?
No, Your Honor.
Judge.
Mr. Rossi. Mr. Baldwin.
Sorry. These are unusual, you know, with sequestration, it's a little bit unusual. Does the court have an idea of, will they just go all the way through, but if it's midnight and they want to go to bed, is there some manner in which?
What is the schedule, is that what you're asking me?
I guess so, yeah.
The schedule would be they're out right now and selecting a 4-person, I presume. I'm anticipating letting them go back to the hotels around 4 o'clock, and that they would, then, reconvene tomorrow morning about 9 o'clock.
Oh, okay. Thank you.
And then they go until 4 again and reconvene. We will be working Saturday, much as we've been working Saturdays in the past. We will not be working Sunday, everybody needs a day off. And the jury will not have access to their electronic devices, they will not have access to their families in that time frame, as well, so I'm sure I just want them to continue to work.
So 4 o'clock would be kind of the closing hour, unless they communicate to the bailiff that they want to keep at it or...
Yes.
Okay.
Yes.
I've had those circumstances.
Yeah, and they may want to keep going.
Yeah.
And if that's the case, they'll keep going. I will stay at the courthouse with my court reporter, as well, just in case they do have questions, and I need to contact counsel too.
Okay.
Get your input on how you want me to answer questions and if they want to see any evidence, but I would absolutely contact counsel to let you know if they have questions, if they want to review the evidence, and if you want me to contact you when they go home, back to the hotels, I'm happy to do that as well, if you wish.
That would be great, just so we know when the day's over, yeah.
Just so that you know you're kind of off the clock, okay?
Yeah.
Okay. Anything else?
No.
I left our numbers with Ms. Williams.
Okay. So do we need to get numbers for the state, then?
We'll do that, Judge. Thank you.
All right. Just thank counsel for your excellent final arguments, appreciate the manner in which you presented that information to the jury. Very well done. And we are off the record, Jody.
Off record at 1:27 p.m. On record November 9, 2024 at 10:03 a.m.
All right. Well, you may be seated. We're back on the record. The jury has sent out a note indicating they would like to see Exhibit 290, the first interview, 246, the enhanced video, 207, audio only, and then they sent out a note this morning that they wanted to see the second interview, Exhibit 291. So we're in the courtroom, outside the presence of the jury. I don't know who all of these extraneous folks are. I apologize, I made it an invitation to the attorneys to appear here, not on staff members. I do need somebody from the state staff to run the equipment, so would you please stay to run the equipment? And I'm sorry, I'm pointing at you and I don't know your name.